Today, we are excited to have a presentation by Dr. Ryan Thoreson. In recent years, state legislatures have filed hundreds of bills targeting LGBT rights, particularly the rights of transgender children. Many of these have passed into law, barring transgender people from accessing gender-affirming care, participating on sports teams, using bathrooms and other facilities, and presenting themselves consistent with their gender identity. This presentation will reflect on recent legislation and litigation and the impact that it has had on individuals, families, and communities, and offer thoughts on what the struggle for trans rights will involve in the years ahead. Ryan Thoreson is assistant professor at the University of Cincinnati College of Law, where he teaches and writes on constitutional law, international human rights, and law and sexuality. Previously, Dr. Thoreson was a researcher in the LGBT rights program at Human Rights Watch, where he worked on reports on LGBT issues in schools, religious exemptions, healthcare access, and also worked on anti-transgender violence. He holds a law degree from Yale Law School, a doctorate in anthropology from Oxford University, and a bachelor's degree in government and studies of women, gender, and sexuality from Harvard University. Dr. Ryan Thoreson, we really look forward to your presentation today.
Awesome. Thank you for having me, and thanks for coming this morning to everyone who's attending. So I've worked on transgender rights in the United States since about 2015, when I started a research project examining the issues facing LGBT kids in the US at Human Rights Watch. And for that project, I traveled around the US interviewing young people in South Dakota, Utah, Pennsylvania, Alabama, and Texas about the challenges that they were facing in schools. And this was right at the start of the anti-trans bathroom backlash, where the Obama administration had ruled that excluding transgender children from bathrooms and locker rooms would constitute sex discrimination. And many local school districts had passed policies in direct opposition to that. And since that year, I've seen the anti-trans backlash intensify, certainly in the United States, but also internationally, where many right-wing populist governments have targeted transgender rights as a means of stirring up support from the population. And I've seen opponents kind of cynically cycle through a series of issues that they feel will be politically advantageous each year. So if you'll remember, initially it was the bathroom bans, and then there was a whole year or two where lawmakers were targeting transgender kids in sports. Then gender-affirming care was in the news. Last year, I think drag bans were kind of the new flavor of the month, where lawmakers were attempting to cast all drag performance as obscenity, and with a broad brush kind of exclude drag performance from the public sphere. So I'm going to break today's discussion into three parts. First, to kind of set the scene for LGBT rights protections in the US generally. Second, to look at some of the legal questions that are unresolved and what the future of these existing challenges might be. And then finally, reflecting on where we go from here. Now that it's Pride Month and we're thinking critically about what the future of the movement looks like, to kind of think about the lasting implications of some of these bills and what they might mean for LGBT advocacy going forward. So first, to kind of set the scene. So for the last 7 years before moving to Cincinnati, I used to live in New York City. And while I think especially during Pride Month, it's easy to celebrate the tremendous strides we've made, particularly in larger urban environments, social change has really outpaced legal change in the United States in a lot of ways. So first, there are virtually no federal non-discrimination protections around sexual orientation and gender identity at the federal level. There is a bill called the Equality Act that many of you are probably familiar with, that's been reintroduced for decades now in various forms. And that would expressly prohibit discrimination on the basis of sexual orientation and gender identity in things like employment, housing, education, public accommodations. federally funded programs, credit, jury service, kind of a range of things that are protected for other groups under federal law. But the Equality Act can't garner the 60 votes necessary to defeat a filibuster in the US Senate, and therefore hasn't become law. Even though there is widespread public support for the Equality Act. PRRI, which is a public polling firm, has found that a majority of the public in every US state, even deeply conservative states, support basic non-discrimination protections on the question of sexual orientation and gender identity. But for various reasons, that has not translated into support in the US Senate. Even President Trump's ban on transgender military service, which triggered an outcry from some fairly conservative members of Congress, didn't trigger congressional action or a statutory remedy. There's just little incentive for policymakers to find compromise and work to pass basic common sense protections in the current climate. And I think this is particularly true as these anti-trans attacks have intensified, and even support for non-discrimination for trans people quickly turns to the question of trans people in sports or gender-affirming care for minors, and away from kind of basic common sense protections that everyone can agree on, like the fact that people shouldn't be evicted for being transgender or shouldn't be turned away from a healthcare provider simply for being transgender. And those basic protections just haven't been enshrined in federal law. For this reason, LGBT people are really hyper vulnerable to regulation under state law. And those state law protections tend to fall on partisan lines across the United States, particularly in recent years. So there are still only 23 states in the US, less than half, that prohibit discrimination on the basis of both sexual orientation and gender identity in things like employment and housing. And only one other state prohibits discrimination on the basis of sexual orientation alone. Only 28 states prohibit discrimination on the basis of sexual orientation and gender identity in adoption and foster care services. Only 21 states prohibit bullying on the basis of sexual orientation and gender identity in schools. Only 31 states have an easy form to change the gender on your driver's license or other basic identification if you're trans. And only 26 states will change your gender on your birth certificate without sex reassignment surgery or a court order. Only 22 states prohibit so-called conversion therapy, which has been roundly rejected by medical bodies. And they tend to do so through licensing boards to kind of deprive people of their licenses rather than using civil or criminal penalties that sometimes have more teeth against conversion therapy. And that's because of the First Amendment and the restrictions that it places on how the federal government can regulate the provision of medical services. In some ways, I think the LGBT movement has become a victim of its own success. After winning marriage with the decision in Obergefell in 2015, there was a sense among a lot of advocates that major victories had been won, even as these kind of basic fundamental protections, like protection from employment discrimination, hadn't yet been passed into law. And winning those, I think, has become difficult as people sort of assume that LGBT people are not at risk of discrimination, at the same time that opponents of LGBT rights have really zeroed in on trans people and the most marginalized members of our communities to stir up political hatred. So second, to kind of set the table, I think one thing to note is that the scattered protections that do exist for LGBT rights often aren't particularly durable protections. So I'll give one example. So in 2020, the Supreme Court ruled that the term sex in Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based on race, religion, sex, and other grounds, should be interpreted to include sexual orientation and gender identity. And this was an opinion written by Justice Gorsuch, who's normally a fairly conservative justice. And his argument was that, when you are discriminating on the basis of sexual orientation or gender identity, fundamentally, you are discriminating on the basis of sex. If Paul is discriminated against because he is married to Brian, he would not be discriminated against if he was Paula, right? It is because of his sex that his relationship with a man is the grounds for employment discrimination. And so therefore his sexual orientation is in some way fundamentally about his sex. And the same thing could be true for transgender individuals, right? Someone who has transitioned or is presenting consistent with their gender identity at work would not face discrimination if they were presenting consistent with their sex assigned at birth. At bottom, that is a form of sex discrimination. So the Biden administration has interpreted that holding in a case called Bostock to also apply to sex discrimination protections in other areas. In education, healthcare, housing, there are all federal laws that prohibit discrimination based on sex. And the Biden administration has said, that also prohibits discrimination based on sexual orientation and gender identity. But the Supreme Court has only technically ruled on the employment claim, and it will be up to the Supreme Court or future presidential administrations to decide whether they want to kind of ratify the Biden administration's interpretation. And the danger of these administrative rules and regulations being subject to reversal by future administrations was really evident during the Trump administration, when we saw administrative agencies expanding religious exemptions that blocked LGBT people from obtaining care, banning transgender people from serving in the U.S. Armed Forces, implying the term sex in federal laws to apply only to biological sex, and declining to bring civil rights enforcement actions for transgender rights cases, things like that. The executive branch protections that had been adopted by the Obama and the Biden administrations, which I think are rightly celebrated by advocates, are unfortunately relatively easy to overturn in subsequent administrations. And then the limited legislative protections that do exist have been subject to judicial challenges that seek to elevate conservative litigants' freedom of speech or association or religion above the enforcement of state and federal non-discrimination protections. So we saw this last term in a case called 303 Creative, where a web designer in Colorado challenged Colorado's non-discrimination statute, saying that she shouldn't be compelled to make wedding websites for same-sex couples because that was a violation of her freedom of speech. And the court agreed with her, saying that these kinds of expressive products can't be compelled, even if that means that they're denied to certain groups when they're provided to others who should be protected under state non-discrimination law. Where equality guarantees are concerned, many of the decisions from the Supreme Court and other federal courts have been doctrinally unclear, particularly in their refusal to say whether sexual orientation or gender identity receive heightened scrutiny under the Equal Protection Clause of the 14th Amendment. And then where liberty guarantees are concerned, things like the freedom to marry or the freedom to engage in sexual activity in the privacy of one's home, the Supreme Court's recent rejection of the right to access abortion in the Dobbs decision is a warning signal that certain unenumerated rights under the 14th Amendment's Due Process Clause might be revisited by the court in the coming years. And then finally, in addition to the kind of scattered state landscape and the kind of weak protections that exist at the federal level, the lack of protection leaves LGBT people vulnerable to a kind of populist backlash in the social domain, which we're currently seeing at an unprecedented level. So I'll talk about some of the recent challenges that we've seen legislatively that have been kind of fueled by this populist backlash. Since 2020, there have been hundreds of anti-LGBT bills filed in state legislatures every year, and dozens of these bills every year have become law. They particularly target the transgender community, I think playing on people's relative lack of familiarity with trans folks nationally, relative to their familiarity with gay and lesbian people, and seek to limit trans people's ability to live consistently with their gender identity and really to just inhabit public space. So as of March of this year, 24 states had banned best practice gender-affirming care for transgender youth, and 5 actually punished that care as a felony, subjecting medical providers and potentially parents to felony charges for helping their child obtain gender-affirming care. 11 states have responded by passing a shield law for transgender health, ensuring that trans people are able to get health in their state. And then 3 states have a shield executive order that functionally does the same thing. 24 states have a law that bans transgender students from participating in sports consistent with their gender identity. And one state, Alaska, does that by regulation. These bills are not aimed at kind of collegiate or professional sports. They often reach as low as kindergarten, essentially banning trans kids from participating in sports, even when some of the arguments that are floated for these bans, like, competitive equity, don't apply. And I'm happy to talk about some of the competitive equity arguments and where those don't hold up, or what alternative models might look like in the Q&A. 10 states now ban transgender people from using bathrooms and facilities consistent with their gender identity in K through 12 schools, and 2 make it a criminal offense, potentially charging trans adults with a crime for using a bathroom consistent with their gender identity. 7 states now prohibit discussions of sexual orientation or gender identity in school curricula, and 4 more restrict how schools can discuss homosexuality in specific curricula like sexuality education. So, not allowing sex ed teachers to talk about same-sex activity when they're talking about things like HIV/AIDS prevention, which is obviously critically important for young people, in the context of sex education, where they're supposed to be learning about sexual health and safety. And then 5 states have a law that forces outing of transgender youth in schools, essentially requiring school staff to report to parents when they become aware that a child might be transgender, often without any real safeguards for the safety of that student in their own home, where we know that family rejection puts transgender youth at risk of being kicked out of the home or subject to physical violence or abuse. As I mentioned, a lot of these laws kind of exploit partial truths or misinformation about transgender people to advance an agenda that lawmakers consider to be politically advantageous in their state. They typically do this by framing transgender people as a threat to other people's rights. So, elevating women's competition in sports at the expense of transgender people participating in sports, or cisgender children's bodily autonomy at the expense of transgender children's bodily autonomy, or parents' rights to raise their children over the right of children to be safe and secure in their own home. And then they justify barring transgender rights or access to gendered spaces on those grounds. So how has this kind of played out in the legal system? As states have passed a lot of have proposed these bills and then passed many of them into law, the second section that I want to look at is how these laws are faring in court, or how the legal system is or is not standing up to some of these bills. I'll focus on some of the violations that are protected under US law. A lot of my work is in international human rights law, but the US has not ratified a lot of the international treaties that protect things like the right to education or the right to health or the rights of children generally. But even under domestic law, these bans do raise real human rights concerns and civil rights concerns. Many of the bans are overtly discriminatory, so they prevent transgender children from doing things or accessing benefits that cisgender children can access. They jeopardize the right to privacy and the right to security of the person by outing transgender children and putting them in situations where they're highly vulnerable to violence. A lot of the restrictions in schools punish teachers, librarians, and other adults for their own gender expression or for teaching about LGBT issues in the classroom, limiting what books are available and what information young people can access. And then bans on healthcare might also threaten the rights of parents to obtain care for their children, or the rights of doctors to engage in protected expression consistent with their own medical judgment. And there have been challenges to pretty much all of these kinds of laws in court, but they've divided along ideological lines, and the Supreme Court has been really hesitant to weigh in on them. District courts, the first kind of line of defense against unconstitutional laws, have been much more willing to conclude that these anti-transgender laws are motivated by prejudice, that they're not backed up by evidence, or that they sweep far too broadly to achieve the kinds of goals that their proponents are claiming that they're meant to advance. But the circuit courts of appeal, which tend to be more ideologically divided and slightly more partisan nowadays, have been more mixed and have upheld some of these laws that have been initially rejected at the district court level. So I'm going to focus here on gender-affirming care as one example where we're seeing some of these arguments play out, and look at some of the legal arguments that are being levied against these anti-trans bills. The first argument that's been really central is an equal protection argument. And this is the Equal Protection Clause of the 14th Amendment guarantees that everyone should enjoy equal protection under the law. And that applies to state action as well as federal action. And the central argument here is one that the Supreme Court recognized in the Bostock decision in 2020. When it found that Title VII's prohibition on sex discrimination also prohibits discrimination based on sexual orientation and gender identity. In that opinion, Justice Gorsuch wrote that, quote, "It is impossible to discriminate against a person for being transgender without discriminating against that individual based on sex, because the discrimination targets, quote, traits or actions that would be permissible but for the person's sex assigned at birth." A lot of the federal cases that have been brought have also contended that discrimination on the basis of transgender status should be subject to a kind of heightened scrutiny by the Supreme Court, where they demand that the Supreme Court, or that they demand that state legislatures have a very good reason for treating this group differently than they treat other groups. Overall, 9 of the 8 district courts that had ruled on these cases in late 2023 held that they violated the Equal Protection Clause. So almost unanimity among the lower federal courts at the district court level that these laws violate the Equal Protection Clause. And actually, a panel of the 8th Circuit Court of Appeals agreed, and the 9th Circuit Court of Appeals has denied a stay of an injunction in Ohio pending appeal, which just means that the district court in Idaho had rejected a ban on gender-affirming care, and the 9th Circuit had refused to prevent that ruling from going into effect, essentially blocking Idaho from enforcing its law. Conversely, the 6th Circuit Court of Appeal and 11th Circuit Court of Appeal have found that these states don't offend the Equal Protection Clause, as they don't discriminate on the basis of sex in those courts' opinions. And they're therefore subject to a lower standard of review that the courts believe these laws easily satisfy. But the landscape is likely to get considerably more complicated. In the context of access to bathrooms and other related issues, for example, the 4th Circuit Court of Appeals and the 7th Circuit Court of Appeals have found that anti-trans discrimination is discrimination based on sex. And the 4th and 9th Circuits have already found that transgender individuals are a quasi-suspect class and deserving of greater protection under the Equal Protection Clause. The Supreme Court notably has kind of sat on some of these challenges, as I'll talk about soon, but it leaves a giant question mark over a lot of the lower court litigation on equal protection issues, but also on 2 more issues that I'll discuss. So one of these other issues is a due process challenge, essentially saying that the 14th Amendment's protection of due process of law protects certain unenumerated rights in the Constitution, things like the right to privacy, the right to educate and raise one's children, the right to intimacy and the privacy of one's home or marital privacy. It had protected the right to abortion. Now that has been reversed with the Dobbs decision. But specifically, many of these laws are being challenged on the basis that they infringe the rights of parents to control the care and custody of their children, particularly where parents are being investigated for child abuse, for helping their children obtain gender-affirming care, or in instances where parents have been helping their children obtain this care and now are told by the state that they can no longer do that, even though that might not be in the best interest of their children's health. There is a potential due process claim that some litigants have brought. The 8th Circuit didn't reach this argument, and the 6th and 11th Circuits both rejected it, in part relying on the Supreme Court's decision in Dobbs, saying that there is no fundamental right to an abortion because the framers would not have recognized a fundamental right to an abortion at the time that the Bill of Rights or the 14th Amendment were ratified. And then a third argument that's at least been brought in some of these cases is a First Amendment argument, saying that there is a body of Supreme Court jurisprudence that says that doctors have a right to provide medical advice consistent with their medical expertise, and the state can't gag doctors from providing medical advice consistent with their medical expertise. And to the extent that many of these laws seem to restrict the speech of doctors, prohibiting them from making referrals or recommendations about gender-affirming care under penalty of prosecution or punishment, these might violate the First Amendment rights of doctors. Now, the Eighth Amendment or the Eighth Circuit similarly didn't reach this argument, although the law in Arkansas was found to violate the First Amendment by the district court. And so this also is kind of less likely than the equal protection challenges to reach the Supreme Court on appeal. But one of the things that's really notable about these lawsuits is that the Supreme Court has largely stayed out of these cases on both sides of the issues. So in 2023, they rejected the state of West Virginia's effort to enforce a ban on trans kids playing sports. And in 2024, they declined to take a case where the Seventh Circuit had struck down an Indiana ban on transgender kids using restrooms consistent with their gender identity. And years earlier, the Supreme Court had also declined to weigh in when the Fourth Circuit ruled in favor of a trans boy in a substantially similar case. So it's not, even though the Supreme Court is fairly conservative, and there's certainly been some appetite to overturn fundamental rights jurisprudence, as Justice Thomas signaled in the Dobbs decision, the Supreme Court so far has kind of stayed out of these debates over bathrooms and sports teams and gender-affirming care. And I'll note that this is particularly evident with one of the challenges to gender-affirming care that has now been sitting before the Supreme Court for more than 3 months. In late February, the Supreme Court kind of received a petition for certiorari in the Sixth Circuit's ban on gender-affirming care, where the Sixth Circuit upheld bans in Kentucky and Tennessee that would limit trans kids' ability to get gender-affirming care there. And the Supreme Court has just relisted it 10 times, hasn't taken up the case, hasn't declined the case, just keeps putting it back on the calendar over and over. And one hypothesis for why they might be doing this is that they're waiting to see if there's what's known as a circuit split, where different circuits come out on different sides of the debate over gender-affirming care. And the Supreme Court has to weigh in to get some unanimity across the country on whether the Constitution actually allows or prohibits bans on gender-affirming care. That's become a more challenging argument in recent weeks because the Eighth Circuit has struck down a ban on gender-affirming care, even though that is being reheard within the Eighth Circuit. And now the Fourth Circuit has said that the states of North Carolina and West Virginia can't exclude gender-affirming care from state healthcare plans, saying that that would violate the Equal Protection Clause of the U.S. Constitution, which seems to set up a circuit split that the Supreme Court will have to resolve. But it seemed unwilling to do so, and it has historically been unwilling to do so in the bathroom context and has let different states regulate bathroom policy very differently. And so it's not really clear what will happen with this case and what the Supreme Court is waiting for in taking it up. But regardless of how these lawsuits are resolved, I think the full extent of the damage created by these laws will likely take a generation or more to reverse. We can think back to the marriage equality movement, which is often hailed as a really successful social movement in the US. And that took 10 years of intensive state-by-state organizing to reverse constitutional amendments prohibiting marriage equality at a truly immense cost in movement, energy, and time and money. One single group of funders spent $153 million on the efforts for marriage alone. And there just hasn't been a similar outpouring of support for trans rights in conservative states where it will take sustained investment in movement architecture to reverse some of these bills. Reversing the recent wave of anti-LGBT legislation, which touches on things like the regulation in the medical field, schools, bathrooms, sports, licenses and state identification, criminal law, is likely to be much more diffuse and difficult and require really significant investments in many more areas of law than the marriage equality movement ultimately did. So I'm going to conclude just by going over four lessons that I think are evident from both this history and the current moment that we're in. And I'll be brief with these. I'm a lawyer and I'm trained to think in threes, but I really do think that there are kind of four lessons here. First is that the US has lacked a really robust framework for equality law. And if we look back at some of the abortion rights jurisprudence and LGBT rights jurisprudence, it's really historically privileged liberty interests, the right to get an abortion or the right to have sex in one's home or the right to marry, rather than equality, right? The right of women to access medical care on the same grounds as men, or the right of gay men and women to marry a partner of their choosing, similar to heterosexuals. We need to think about new ways to ensure that equality is taken seriously and what it would look like to really advance equality at the federal level and not just these liberty interests. In the US, LGBT rights are one example, but we can think of others. You can think of the recent demise of affirmative action, which really looked at the kind of individual right of white students to kind of have their applications considered on a race-neutral basis, rather than the kind of structural interest in alleviating historical inequalities around race and education. Or you can think about the debate over gender-affirming care, where the rights of the individual person who has detransitioned and says, I wish I had not received gender-affirming care, is used to license wholesale bans that prevent anybody from obtaining gender-affirming care, including those who would not regret that decision, or for whom that decision is the right medical decision and would alleviate physical and mental health stressors. Or the rights of a cisgender student whose parents don't want them to access certain books or materials in school, even if that means that none of their peers can access that book in school because it's been taken out of the school library, right? We as a country have kind of privileged these individual liberty interests over either the liberties of others or structural equality. And I think that is one of the challenges that litigants are running into in litigating some of these cases. Second, I think there's a real need to humanize LGBT issues to make headway. As LGBT people have gained greater legal protection, we've often, I think understandably, relied on legal precedent to make the case for LGBT rights. So initially with the bathroom bans at the state level, people said, you can't do that. The Obama administration has said you can't do that and that it violates federal law. That's the end of the discussion. Without necessarily humanizing, what does it mean for a transgender student to not be able to use the bathroom for a full day at school? And I remember one interview that I did in South Dakota where this was probably 10 years ago now, a child talked about how every day at the lunch hour, there was no bathroom that they could use in the school without having to use a bathroom that was not consistent with their gender identity. So every day during the lunch hour, they would go to a nearby gas station and use the bathroom. And they just never got to eat lunch with their friends, right? They had to leave the school every day over lunch to go use the bathroom. There's a real need to humanize these kinds of stories and show lawmakers that this is not just a political issue. This is a real life issue that has real implications for the lives of trans kids and their families. And appealing to moral, ethical, and social values in making that case. And this can be complicated, particularly where kids are involved. I think there are real ethical issues with putting children front and center or forcing them to kind of shoulder the burden of being the voice of a movement or front and center. But to the extent that there are, young people and their families who want to speak out against these laws, who care deeply about these laws, I think allowing young people and their families to be front and center and tell their stories and helping to amplify those stories is deeply important. Third, I think we have to think about common cause with other movements. I think it shouldn't be lost on LGBT advocates that in striking down the right to abortion, Justice Thomas wrote a concurrence that expressed a desire to next revisit cases like Lawrence, which allows people to have sex in the privacy of their homes without fear of criminal prosecution, or Obergefell, which protects the right of same-sex couples to marry. And to take seriously the fact that the abortion ruling is being cited by courts as an evidence that there is not a right to access gender-affirming care. LGBT rights don't exist in a vacuum, but in relation to other equality and liberty guarantees. And as we see affirmative action being rolled back, voting rights being rolled back, abortion rights being rolled back, LGBT rights will rise and fall on some of the precedent that is being set in these other cases, and vice versa. What happens with the gender-affirming care cases will have significant repercussions for other movements as well. And finally, I think the current backlash really illustrates the importance of democratic institutions of various kinds. When we see the press, the free press and the media, the judiciary, the academy, all of these institutions coming under attack from populist movements, I think it's really important to recognize that these are some of the institutions that have protected against the erosion of minority rights. And that as those institutions are weakened or crumble, there are few ways to advance minority rights in the face of populist prejudice and polarization and misinformation. And I think where we go from here likely depends on those four lessons. In the immediate aftermath of the Obergefell decision, a lot of LGBT activists and scholars kind of reflected on where the movement would go next, right? Do we focus more on LGBT people in poverty or LGBT issues and race and where those things intersect? Do we invest more attention in transgender equality, in meeting the needs of LGBT children and elders? And I think proactive efforts to address some of those goals that had been imagined by LGBT advocates have just been overwhelmed by the defensive posture of the current moment. And I think one of the real tragedies of the recent anti-LGBT backlash is that it's kind of snuffed out opportunities to imagine a more just society, free from discrimination based on sexual orientation and gender identity, right? So one of the notable things is that the many purple states that have not passed basic non-discrimination protections that seem like they were on the cusp of doing so, places like Wisconsin, Ohio, Pennsylvania, they just stopped. There have been no positive movements to address anti-LGBT bullying, LGBT discrimination in employment and housing and public accommodations. That positive momentum has just stalled out because these issues have become so polarized and partisan. I think in the short term, our legal battles will just by necessity be focused on reasoning from established sex equality law and cabining this backlash as much as possible. And so as a kind of call to action in Pride Month, I think it's really important to highlight these four goals, to humanize LGBT issues and really amplify the stories of people who are affected by these negative laws. To focus on the fact that a third of transgender youth in the US are estimated to no longer be able to access gender-affirming care in their states. 25% aren't able to access that care within an hour of where they live, essentially, putting a huge burden on them and their families in the event that they are able to travel to get that care. To emphasize common cause with other movements and to fight for racial equality and access to abortion and other causes. To stand up for democratic institutions and to really fight for a free press and an independent judiciary and academic freedom. Those kinds of things I think are obviously important year round, but in Pride Month, it's helpful to center those, to not just celebrate how far we've come, but to really reinvest in what this movement looks like going forward. So thank you.
Dr. Ryan Thoreson, I want to thank you so much for your excellent presentation today and for all of the conscientious work that you've done to make sure human rights and the legal process are covering the people, all people, and especially those that are in most need of legal protections. At this point, we would like to present questions to you. And what's going to work best is if anybody wants to ask a question, if you could please write it down. Margaret has graciously volunteered to collect those questions so that I could read them to Ryan Thoreson. I will also say, as you're writing down these questions, this forum is a project of the Human Rights Working Group, which is our congregation's foremost group of people advocating for human rights, legal protections, and justice in our world. I do want to thank Jeff Peckrell, Bruce Newberger, and Dolores Perez Heilbrunn, who helped facilitated today's forum presentation. And I also want to thank our staff members, Thomas Brown and Jonathan Silk, who did a tremendous job of making sure we had the forum today. And if anybody is in chat that wants to ask questions, please type in those questions. We'll be very glad to get those asked. So, Ryan Thoreson, we have a question here. I'm in my 70s and I didn't know anything about transgender until I was in my 40s. And I thought it was very uncommon. Is there information on how frequent this is? Is it a choice? Do people sometimes change their mind? Is gender fluid? Could you answer those questions?
Of course. It's a great question. So I think kind of similar to people coming out as gay or lesbian or bisexual, I think the prevalence of people being out as trans has increased as social acceptance has increased in a lot of the country. Where people may live in an environment where they don't fear being fired, or they're able to access healthcare, or they have supportive friends or family members. Of course, the number of people who identify as trans, just as gay or lesbian or bisexual, will increase in those environments. So I'm trying to remember the exact statistics. I think it's something like 1 to 2% of the U.S. population that's estimated to identify as transgender. So not huge, but certainly a significant portion of the U.S. population. And when we think about these kinds of bans on gender-affirming care, limiting access for young people who might need that care, but also increasingly, lawmakers hinting that they might like to ban this care for adults, affecting 1 to 2% of the population is fairly significant. The Williams Institute has done more research. It's out of UCLA, and they've done more research on kind of the number of LGBT people in different states, and they've got a better breakdown of what the exact proportion might be. And then, as in terms of the choice piece, I think it's kind of similar to gay and lesbian and bisexual folks, where there are certainly people who might choose to identify as LGBTQ or not as a kind of political statement. But I think for many people, whether it's nature or nurture, it's something that people feel can't be changed. It's deeply personal and kind of central to one's sense of being, and that changing it can be really harmful, or attempting to change it can be really harmful or detrimental to people psychologically and in terms of their mental health.
Thank you for that answer, Dr. Thoreson. You mentioned that currently there's no federal statutes that specifically state directly talk about trans rights, and you talked about certain state governments that have made prohibitions of trans participation in sports and in other venues. Are there states that have specific statutes endorsing the rights of trans people and gender nonconforming people?
Yeah, that's a great question. There's an organization called the Movement Advancement Project that has a series of maps that they put online. Their acronym is also MAP, but they have these really useful kind of research guides and maps where they break down how different states have navigated these issues. And I've always found those a kind of helpful resource that's updated really regularly. I'll name a couple of places where I think states have been proactive in passing laws. One area is in shield laws around trans healthcare. So they say, if you are a trans person, you're trying to get healthcare here, you have that right. And also, we will not cooperate with states that are trying to bring criminal charges against you for accessing that care. We will not share your medical records with those states, to kind of shield trans folks who need healthcare from being prosecuted in other states. There are states on the school curriculum front who have affirmatively adopted like LGBT history into K through 12 curricula, and have been proactive in kind of selecting age appropriate resources to talk about LGBT people in the curriculum. And then some states have been proactive in kind of facilitating legal gender recognition, making it easier to change your driver's license or your birth certificate so that trans folks have ID that is consistent with their gender identity and aren't harassed for having inconsistent identification. And then there are many other states that just have non-discrimination laws, right? That say you can't fire someone for being LGBT, you can't evict someone for being LGBT, you can't expel someone from an educational institution for being LGBT. And different states have kind of been more or less proactive in passing laws from that kind of suite of laws that might better protect LGBT people. But certainly I think the Massachusetts, California, New York, some of the kind of usual suspects have been on the vanguard of really protecting these rights in a more robust way.
Thank you. You referred to populism. Please expand on your understanding of the term.
Yeah, that's a great question. So I tend to think of populism as an appeal to the kind of majority sentiment with few checks and balances for minority rights or instances where the majority does not necessarily rule. So certainly in a democratic society, we want the public to be leading lawmaking, and we see many places where that's very healthy and beneficial. Populism, I think, tends to privilege the rights of the majority without any guardrails on their preferences, right? So, that can certainly take place in the LGBT context where it's a majority of people saying we don't want you to have this healthcare. We don't think that this is good for you, and so we're not going to allow you to have it, even if that might be driven by kind of prejudice or animus. But it also can take place in many other areas of rights as well, right? Racial discrimination. If you think of school segregation as a time when prior to Brown versus Board, there were certainly many states in the South where popular sentiment favored segregation. And the difference between a democratic system and a populist system is that the democratic system said, I'm sorry, but there are certain guardrails that don't allow the majority to carry the day in this instance because it infringes on the rights of certain minority groups. And that's kind of where I see the distinction playing out with some of these issues as well.
Thank you. Do you or the statistics show that a decision early in life regarding gender transition is regretted later in life? What are the choices to reverse the decision?
Yeah, that's a great question. And in the presentation, I probably should have gotten more into kind of what gender affirming care involves and what the kind of guardrails are in that provision of care. So the rate of detransition is actually very low. Something like, I'm trying to remember, like, again, 1% to 2%. But there are a few people who kind of regret detransitioning or regret transitioning, and that often it's tied to social circumstances. Like, I regret transitioning because I've found it difficult to find a job. I've been rejected by my family and friends, kind of related to the prejudice that people have faced after transitioning, rather than I regret transitioning because I do not think that I'm actually transgender, if that makes sense. So one of the things that I think is important, though, for all young people is that you do need support in making these decisions. Like any medical decision, I think providers of gender affirming care are insistent that there needs to be informed consent and there needs to be a full understanding of what different steps along the way might allow or foreclose later in life. So I'll talk about kind of three pieces of gender affirming care. The first is as young people start puberty, young people can be put on what are known as puberty blockers that kind of prevent the body from going through puberty and just kind of hit pause on puberty. And so those can be useful if a young person, maybe thinks that they're transgender and doesn't want to go through puberty because, say, I say I am a transgender boy. I was assigned female at birth, but I identify as male. I don't want to go through female puberty because those changes become much harder to reverse as an adult, and it will be harder for me to kind of live in the world as a man if I go through female puberty. So puberty blockers kind of put that on hold. Those tend to be understood as reversible, that once you stop taking them, you go through endogenous puberty. So you would be able to kind of go through puberty if you decided you were not transgender. Later, usually in like adolescence, when the young person can consent to more permanent changes, young people might start other hormones. So essentially the same hormones that one would take to transition as an adult. They help start to actually develop secondary sex characteristics for the gender identity that the young person identifies with. So you would start going through, kind of male puberty if you are a transgender boy, or female puberty if you were a transgender girl. That's obviously done in consultation with a physician, and there are kind of guardrails that have to be followed to make sure that the young person understands the consequences of that, because that can limit fertility later in life, or have other consequences that the young person really needs to be informed about and understand for that to proceed. And then a lot of these bills really focus on surgery, which is generally not recommended for children under the age of 18, right? So surgery is kind of front and center in some of the public discourse around these bills, but really surgeries don't happen on people younger than 18, except in some situations where someone is in such acute distress over their gender identity that they, urgently need some kind of intervention. Usually that's top surgery, or either the removal or the implantation of breasts. So surgery generally does not occur, but that would be when a young person has consent, because that is a permanent intervention. And that's why healthcare practitioners usually wait until the age of 18. But I think, one of the things that I think advocates have really been, that is important to emphasize, is that it's not that medical institutions are just handing out this care left, right, and center. It's much more common that young people who are transgender can't access this care, right? Can't afford it, don't have supportive parents. There isn't a place nearby them that provides it or is allowed to provide it. That there are so many obstacles to getting this care, that really, what is needed is more of an investment in, we need people counseling young transgender folks about the options and choices that are available to them, making sure that this is the right path for them. And I think supporting young transgender people who don't want to medically transition, right? That we're not, if you look at some of the bans on participation in sports at the state level, some of them say, or collegiate bans say, you can't participate in women's sports unless you've medically transitioned. And that's maybe pressuring young transgender girls who don't want to medically transition to have to do that and to be able to participate in sports. And so, I think we need to create space for young transgender people not to medically transition, and to still be respected and recognized as their gender identity for things like bathrooms and sports, without pressuring them into medically transitioning and treating it as a binary choice in a way that I think a lot of state legislatures are now.
We have a question that kind of addresses what you just mentioned there. I'm going to try to quote the question as well as I can here. So the questioners ask, the question of trans girls playing in girls' sports. It is incontrovertible that male markers in sports are higher than female in every sport. International sports organizations have standards, tests, and other things for women's sports. So how can you justify a trans girl playing on the girls' side? Doesn't the unfairness to cis girls matter? End quote.
Sure, no, happy to answer that. So the first thing that I'd stress is that this is kind of the competitive equity argument, that transgender girls are at a kind of inherent advantage over cisgender girls, and are likely to take competitive victories or scholarships or other things like that away from them. There have been a couple very high profile examples, like Leah Thomas in swimming, or the two track athletes in Connecticut that are held up as examples of this. And I'll focus on kind of 3 points. So first, I think it is notable that the NCAA, International Olympic Committee, bodies like this do have standards on gender in sports. And the restrictions that are being placed on like K through 12 athletes in the United States are more demanding than the Olympic standards. So the Olympic standards and many states before this wave of anti-trans legislation have things in place where they look at the kind of specifics of a person's situation, right? Is this person, do they just identify as male or female, or have they undergone medical transition that gives them an advantage? And then kind of calibrate which team they play on based on their kind of individual medical history. So one question is, why are we subjecting second graders to harsher standards than Olympians are being held to? If the International Olympics Committee is not concerned about fairness in some of these dimensions, where why do we worry about it with second or third graders playing recreational sports? The second thing that I would emphasize is just that a lot of the states that had those kinds of fine-tuned mechanisms in play were equipped to address the competitive equity concerns. If you look at states like South Dakota or Ohio, they both had kind of high school athletics association policies in place that said, if you're a transgender girl and you want to play on the girls' team and you've been on gender-affirming hormones for more than a year, we'll look at your testosterone levels relative to cisgender girls. And if you have kind of the same testosterone levels as cisgender girls, or your hormones are kind of functionally the same, and you don't have a competitive advantage, we'll allow you to play with the cisgender girls, which allows many, but not all, transgender girls to participate in girls' sports and have that kind of social validation and outlet for physical and mental health without any competitive equity concerns. The Ohio legislature said that's not enough. Transgender girls cannot play girls' sports, even if there's not a competitive equity concern. And that, just is discriminatory. It's not serving any interest that the state has in competitive equity. It's going much further than that. And then the last thing that I'll say is that a lot depends on the kind of sport that's being played, right? And this is recognized in other dimensions of sports as well. Field hockey or football might be different than like an intramural chess league or volleyball or other sports where there's not a clear-cut physical advantage, particularly in early adolescence, which I think also raises this question of what are K through 12 sports for, right? Are they for scholarships and winning, or are they also for participating and being part of a team and sharing in an experience with your peers? And if they're just about kind of crowning the strongest or the fastest child in the state of Ohio, then maybe we approach them one way. But really, these bans apply to sports that don't have scholarships at stake, that don't have state championships, that are designed to be promote physical and mental health and a sense of belonging and teamwork and things like that. And we're depriving transgender children of participating in those sports when they are at some of the most need of that kind of community, right? They're often, if we look at kind of studies that are done, at increased risk of depression, suicidality, anxiety, have greater physical health concerns with higher, things like tobacco use and things like that. There are good reasons that we want to encourage transgender kids to participate in sports. And states have really not taken the needs of trans kids into consideration at all with these just blanket bans of any participation, when I think there used to be a much more nuanced system in place, even allowing for those competitive equity arguments in some sports.
Are you able to talk about the First Amendment rights for physicians relative to abortion conversation decision in states that prohibit abortion?
Yes, yeah. So, there has been some Supreme Court precedent in the past around kind of crisis pregnancy centers, right? And there's a famous case out of the state of California where California had required crisis pregnancy centers to kind of notify patients that they were able to obtain an abortion from the state if they wanted one, that was accessible and available to them. And the Supreme Court essentially said, you can't compel medical providers to provide that information because it violates their First Amendment rights. And now a similar argument is being raised both on behalf of those who want to provide abortion-related care or want to provide gender-affirming care, saying, if the state can't compel some healthcare providers to provide, kind of neutral information about services that are available to patients, you also can't ban us or criminally penalize us for providing that information to the parents of children seeking gender affirming care or to individuals who are seeking an abortion. And I think it will be interesting. There's so many cases kind of playing out around these issues in the wake of Dobbs, but I think it'll be interesting to see how some of the mifepristone litigation comes out, whether and to what extent medical providers in different states are able to inform people of types of care that are not allowed in that state or make referrals to places out of state where they can obtain that care, and whether the Supreme Court is consistent with its prior precedent, or whether it finds ways to carve out abortion rights and trans rights and allow providers to be criminally prosecuted for providing information about that care.
Thank you. We have time for just a few more questions. If anybody on chat or if anybody would like to write down additional questions, I'll ask this. You had mentioned that there's been a lot of progress in our society for the legal protections for LGBT people when it comes to like marriage protection and marriage equality. It may be the case that 60 years ago, there was a lot of stigma attached to gays and people with alternative sexual orientations. But over the past 60 years, some people were willing to come out and say what their orientations were as a way of demonstrating how many gay people there are in our society. You mentioned that there may be between 1% and 2% of people that are trans, intersex, or gender nonconforming. Do you think it's a reasonable strategy to have people come out as trans, even in an era when there's a lot of stigma and oppression? Do you think that's reasonable to ask trans people to do?
I think so much, that's a great question. I think so much of it depends on personal circumstances, right? I don't think that trans people in particularly hostile environments have any kind of moral obligation to come out or to make that known to people around them. And I think in the particular moment that we're in, there is a very real safety and security risk to doing that in a lot of places. I do think that there's a role that, or I have felt that there's a role that I can play in kind of, I don't know, amplifying or sharing stories of trans friends who are out and are comfortable with that in a way that maybe brings those experiences to acquaintances or others who may not know trans people in their day-to-day lives, right? So I often think of, like a relative of mine who is a trans man, is raising 2 kids, and, looks very masculine, right? I think most people would not know he is trans. He's under no obligation to kind of disclose to others that he's trans. But I often, think of his story or when it's comfortable or safe to do so, share his story in obtaining gender affirming care, needing to update his documentation, because it allows him to be more comfortable in his own body, to be himself, to raise his children without fear of being, harassed in a bathroom or assaulted in public or harassed by a police officer who pulls him over and sees that his his driver's license has a female gender marker on it. That there are any number of reasons why, even if some people don't want that care, don't like that care, feel that others might reject that care, it's care that he needed and that has made his life livable in so many ways. And I think to the extent that we can kind of share those stories or push back on anti-trans sentiment, I feel that as more of a moral obligation than I would for trans folks to come out in a situation where they're not safe or secure.
Another questioner asked, I'm confused why the 14th Amendment doesn't cover transgender rights and all rights. Will passing of ERA, Equal Rights Amendment, help?
Yes, so I do think that passing the ERA would help. One of the difficulties with the Equal Protection Clause of the 14th Amendment is that it doesn't spell out categories, right? So it says, everyone is entitled to the equal protection of the law. And then the Supreme Court has kind of built out different levels of scrutiny that legislation has to pass to either comport with or violate the establishment or the Equal Protection Clause. So race, religion, nationality, discrimination, race and nationality discrimination has to survive strict scrutiny. The government has to have a compelling interest and it has to be the least restrictive way of advancing that interest. For sex, it's only intermediate scrutiny. So the state just has to have an important or substantial interest, and it just has to be substantially related to that interest to pass legislation. And then other categories like disability or we'll use disability as an example, only has to pass rational basis, where the state just has to have a legitimate state interest and the legislation has to be rationally related to that state interest. So one of the challenges is that some courts have said, transgender status is sex discrimination, and therefore we apply intermediate scrutiny, and these bans and restrictions on trans people don't survive intermediate scrutiny. Think of transports as an example. This is not the least restrictive way of advancing competitive equity. You could have a kind of individual determination basis that allows a lot of trans people to play. Doesn't survive intermediate scrutiny, or the gender-affirming care bans don't pass intermediate scrutiny. You could imagine more fine-tuned regulations of medication that serve the state interest without just banning any transgender child from obtaining any form of gender-affirming care. Other courts have said, we don't think that this kind of transgender discrimination is sex discrimination, and so it only gets rational basis review. And there they've generally found that these bans pass muster. So I think one of the things that the Equal Rights Amendment would be really helpful for is that it would just explicitly say in the Constitution, sex discrimination is not permissible, and would give even stronger grounding for federal courts to say, sex discrimination is just not permissible. You can't discriminate on these grounds, and it's not subject to these kinds of fine-grained tests where courts are coming out different ways in different parts of the country. There's a more unitary standard that we're applying when it comes to sex discrimination, and just saying that it is not okay. And that would provide a lot more protection for transgender rights as well.
I'm going to ask a general question, if you don't mind. We're having a speaker next week that is speaking about law and legal rights. Do you want to comment, Dr. Thoreson, about whether the United States government and its elected officials should be sanctioning or undermining the work of the International Court of Justice or the International Criminal Court? Is that something you would like to comment on?
Yes, I feel pretty comfortable saying that they should not be undermining those courts. I tend to think that there is a really valuable role that the ICJ and the ICC both play. And I think one of the reasons that the US has, it's not a secret that one of the reasons that the US has been particularly hostile to the International Criminal Court is that it does not want its own actions to be scrutinized by an international court when it comes to things like the invasion of Iraq, right? That whether or not that was a crime of aggression or was whether, war crimes or crimes against humanity were committed as a part of that. The US does not want to be held accountable to international courts in that way. And so we see this weird kind of bifurcation where when the ICC does something like sanction Vladimir Putin, or express an interest in investigating the war in Ukraine, the US kind of praises that, lauds it, talks about how important it is for people to be held accountable. And then when the US or allies are potentially at risk of being investigated, the US rejects it, says it won't cooperate, kind of undermines the court. And that's just not how a system of justice can work. I think if the US has really invested in a kind of robust liberal order, kind of lowercase l liberal order, that holds all states to the rules of war and takes seriously things like genocide and crimes against humanity and war crimes, it has to be part of that system, and it has to allow prosecutions to proceed and be investigated fairly, whether it's allies or friends, or whether it's those with whom the United States is in conflict. And I think there's real value in having kind of a neutral and genuine commitment to a robust system of international criminal law.
And at this point, I think we're going to have a last rhetorical question for you, Dr. Ryan Thoreson. Will you accept our appreciation for this excellent presentation and for your work on behalf of trans people and protecting the rights of all people?
Yes, and thank you. I mean, thank you for having me. It's really great to be able to share some of this with folks and have these discussions, and the questions were all excellent, and really appreciate that you bring folks in to have these kinds of conversations.
Dr. Ryan Thoreson, everyone.
Thank you all.
So I want to thank everybody for coming today in chat and in person. We do want to announce next week forum will be meeting again here at 9 a.m. June 9th. We will be having a presentation by Nathan Gandrid, who is a law student at the University of San Francisco, focusing on public interest law and tenants' rights. He is currently a law clerk on the impact litigation team at the National Housing Law Project. In 2022, he won the McFetridge Award for Creativity in Trial Advocacy and was invited to join University of San Francisco's mock trial team this fall as it competes in the annual San Francisco Trial Lawyers Association mock trial. Nathan Gandrid, it is a appreciated friend of this community. It'll be a delight to have him present at next week's forum. Thank you, everyone.